Hey everyone, we're going to get started in just about 5 minutes. We just want to make sure everyone that's on already can hear all right. So if you can hear, if you could just raise your hand in the meeting or type into the questions box that you can hear us. Again, we'll get started in about 5 minutes.
Hi, everybody. This is Chris Coleman from the Tennessee Justice Center, and we are going to get started in about 1 minute. Hi, everybody. This is Chris Coleman from the Tennessee Justice Center, and this is the webinar on the new proposed regulations around public charge. So I'm going to go through some of this, but just wanted to welcome. Glad there's nothing else in the news going on right now, so thank you for joining us. So a little bit about TJC for those of you who might not know. We are a nonprofit law firm in Nashville that works statewide. We do individual casework, we do training and technical assistance, and advocacy work. On our individual casework, in 2017, we assisted over 1,300 clients and provided over $6 million in value to clients. We focus on FinCare, and within that, choices, ECF choices, redeterminations, appeals, service appeals, Medicare savings programs, and we do SNAP as well. We provide ongoing training and technical assistance, such as this, and continuing education for social workers, attorneys, navigators, assisters, and provide technical assistance to our partner organizations. And we do a lot of advocacy work around these issues, both on health and benefits, and nutrition and hunger. We collect stories. We are working on an Insure Our Kids campaign, but many of you on the call probably already know all this. So let's get to what we're here for. So what is public charge? Public charge has been on the books in the U.S. since 1882. It's one of the oldest reasons for the U.S. has turned people back at the border or not allowed people to enter the country, is the idea that they were, quote, likely to become a public charge, that is likely to become primarily dependent on government assistance to maintain their livelihood. This language is added to the Immigration Act of 1882. The other immigration piece that was, immigration law that was passed in 1882 was the Chinese Exclusion Act. So if that gives you any sense of where the country was when this law came into effect, that's a good indicator. And at that time, this public charge law was interpreted to mean that immigrants had to show they had $25 in cash when they arrived in the U.S. And then it was a hard test to pass. About 70% of the immigrants who got turned back between 1890 and 1920 were barred on public charge grounds. But these standards got really more lenient over time, and by the 1950s, less than 1% of the immigrants turned away from the U.S. Were turned away on the grounds of public charge. So when is this assessed? So there are two times when immigrants apply for permission to enter the U.S., or when they're already in the U.S. and they are applying to become lawful permanent residents, when they're applying for green cards. So once someone is a lawful permanent resident, the public charge rule no longer applies. It's not a test for citizenship. It's only a question for permanent residence or entry into the country. And there are lots of exemptions. Notably, refugees and asylees are not subject to the public charge rules. And I'll talk a little bit more about exceptions. Refugees and asylees, survivors of trafficking and other serious crimes, self-petitioners under the Violence Against Women Act, special immigrant juveniles, and people applying for temporary protected status. So that leaves people outside the U.S. who want to enter the U.S., family members of people already in the U.S., people within the U.S. who have a status that it would allow them to become legal permanent residents. And then it does not apply to undocumented immigrants because undocumented people cannot become legal permanent residents while they're still in the country. There is no path to citizenship right now for those people. And what we're talking about now are changes to the regulations. There is still a statute in the Immigration Act of 1882. And then in 1996 is when the major law was passed. The 1996 Illegal Immigration Reform and Immigrant Responsibility Act created a specific set of considerations when someone was applying for entry or for LPR status that include age, health, financial resources, dependence, and skills and work experience, and whether the person has a sponsor in the U.S. All of these are questions about whether the person has the ability to support themselves and any dependents that they have. And this rule was then clarified in field guidance that was put out for immigration officers who had started denying applications from from immigrants who had taken any form of public benefits. So the Clinton administration clarified the rule. And so under the policy, this field guidance that they put out, there were only 2 public benefits that were considered. Cash assistance, so SSI or TANF, and institutionalization for long-term care at government expense. So in Tennessee, that would be the Choices program. Those were the only 2 things considered. And this field guidance is still in effect right now, but it's never been formalized as regulations, and that's what got us into the situation we're in now. So where are we? This current public charge definition, the one before this proposed regulation is out, is pretty narrow, and the government rarely rejects applicants based on public charge anymore. This new Trump administration proposal is a far-ranging inventory into the immigrant's history and economic prospects, and it gives enormous discretion to the U.S. and Citizenship and Immigration Services to reject an immigrant's application or for either admission or for a green card because the officer doesn't feel the immigrant makes enough money to support a large family or doesn't have the resources to pay for medical care for pre-existing conditions, has a disability that looks like it might require care. This is a real change, a massive change to what we had before. It's a new kind of invisible wall that the U.S. is erecting that will allow entry only to the highest bidder, to people with lots of money, above 250% of the federal poverty level. I will expand on that a bit. But it is a major shift. Many of the people in the country right now, hardworking immigrant families, would not be admitted to the country after this rule is passed. So that's what I hope the message you will get is this is a radical reshaping of U.S. immigration policy. Since the Trump administration could not get any kind of immigration reform from Congress, they are going around the legislative process and doing this through the regulatory process. So this new regulation, the proposed regulation, it extends the public charge assessment to persons applying to extend non-immigrant visas or to change the category of their non-immigrant visas. So it's more people are going to be considered under this. It changes the definition of public charge to a person who uses or receives one or more public benefits that I'll go over. It is still a totality of the circumstances test. This is not, oh, if you have this, you're rejected, or if you have this, you're automatically admitted. But they look at the entire totality of the circumstances, and that's one of the problems is how much discretion this gives to immigration officials. And it defines public benefits as federal, state, local, tribal cash assistance for income maintenance, so cash, and certain non-cash medical, housing, and food benefits. Now, this rule, the proposed rule does have some significant distinctions from the leaked rules. There were a couple of drafts leaked earlier, and this rule is still bad, but I do want to just mention that advocacy efforts already have played a role in slightly narrowing this. So in the draft rule, there was a catch-all public benefit, any other form of federal, state, local assistance. And the bigger change, and the more important one, I think, is, and this is important to get out to immigrant clients, is the use of benefits by dependents, children, or people not seeking the benefits are not going to be considered. So we're only looking at the applicant themselves. So that is different than the proposed rule, and I think a lot of pushback from advocates around the country really made a difference in getting that part excluded. So no longer will, say, the receipt of SNAP benefits for a citizen child be considered against a parent who is seeking to change their immigration status. But I don't want to, it's certainly not all bread and roses now. The rule is still very bad. So let me go into a little more detail about the specifics of the proposed rule. The rule breaks up public benefits into two types, into monetizable benefits and non-monetizable benefits. And these count when the value of the benefits that someone is receiving on monetizable benefits. They look, does that account for 15% of the immigrant's household size for a year? If the value of the benefit exceeds 15% of the federal poverty level for the immigrant's household size for the year. And the cash assistance they're looking at is SSI, TANF, which in Tennessee is Families First, and then in other states, Tennessee doesn't really have this, but other states offer state-based cash assistance, often called general assistance. And then are what are things called monetized non-cash benefits, and these are SNAP and Section 8 housing assistance. And then we have the non-monetizable benefits. These are considered if the person receives these non-monetizable benefits for more than 12 months in the aggregate during the preceding 36 months, or for 9 months when they're also receiving some monetizable benefit. So each benefit is counted separately. So if you get 2 benefits in the same month, that's 2 months. If you're on, say someone is getting SNAP and Medicaid, those 2 benefits together are going to count for 2 months. There are some exclusions for emergency Medicaid and school-based benefits for children, but it does include the non-monetizable benefits include Medicaid, long-term care, Medicare Part D extra help, which is Medicare Part D is the pharmacy benefit for Medicare, and subsidized housing, non-Section 8 subsidized housing. Now, interestingly, the one category that is not included here, either in excluded benefits, there are some benefits that are specifically excluded that I'll show you next, but that's not included is the CHIP program, Cover Kids in Tennessee. And the proposed rules ask specifically for comments on what they should do with CHIP. And that's very, very important, and I think I will point out a call for comments later. But CHIP is the main benefit that immigrants receive before the 5-year bar, because when looking at CHIP for pregnant women, they do not look at citizenship or immigration status. So that's a big worry, and I think we're going to have to weigh in on the CHIP thing as much as possible to make sure that is not included as a countable benefit. So just to reiterate those things, the individual use of a monetized benefit over 12 consecutive months that total more than 15% of the federal poverty guidelines for a single person household, so $1,821 in 2016, or the individual use of non-monetized benefits for more than 12 months in any previous 36-month period, or any individual use of monetized benefits plus individual use of non-monetized benefits for more than 9 months in any previous 36-month period. So these are different arrangements of what kinds of benefits people can receive and for how long. And failing to pass one of these tests, any one of these three, is what's considered a strongly weighted negative factor that will generally lead to someone getting labeled as a public charge and denied entry or denied permanent status. Some things that are excluded, as I said, emergency and school-based Medicaid. So emergency Medicaid and school-based Medicaid are not included. Emergency and disaster relief. Services that are available to the community as a whole. Public health services, so immunizations at the Department of Health or something like that. School-based nutrition service and public education, including Head Start. That was a big worry that Head Start was going to be included. It is not. And benefits, military benefits and reservist benefits, including for their spouses and children. None of those will count toward public charge. Another important piece, and this is a very important information to get out to immigrant clients, is that this is not retroactive. Right now, the rule, and I'll talk a little bit more about the timeline, but only when the rule becomes finalized will they start looking forward into the public charge rule. Nothing has happened yet. All this is a proposed rule, and even when it goes into effect, it will not, someone's receipt of benefits now will not affect what happens to them after the public charge rule goes into effect, in whatever form it finally goes into effect. So beyond that, we still have the statutory factors. These are things in the 1996 immigration law, and there they consider age, so working age to the minimum age for Social Security retirement, and they consider the impact of that on the ability to work. They consider health, whether the person is diagnosed with a medical condition that would either affect their ability to work or require expensive care. So people with pre-existing conditions and disabilities are more likely to be excluded than able-bodied people. They look at household size. Importantly, they look at income. So specifically, DHS would consider whether the individual has an annual gross household income of at least 125% of the federal poverty level, which is it's about $26,000 for a family of 3 this year, and having an income above 250% of the federal poverty level would be considered. I'll talk more about heavily weighted factors, but that's heavily weighted. So this really is a shift to make it more difficult for low-income working people to get into the country. People who are coming here to make better lives and to work, this is an attempt to exclude them unless they already have a lot of money. And they look at skills and work experience, including language. So proficiency in English is a positive statutory factor. If someone, I don't have a separate slide on this, but there's also what's called a public charge bond. If someone is found inadmissible based on the public charge determination, the person can submit a bond, but these bonds, they would have to put in $10,000, and if they ever then use public benefits, they would forfeit their $10,000 bond. So this is another way where they really are making admission to the country dependent on wealth. And then I mentioned the heavily weighted factors. These, as I mentioned, this is a totality of the circumstances test without any clear guidance for immigration officials to weight the factors except these heavily weighted factors. So the negative factors that are heavily weighted are someone who's authorized to work but is not currently working and is not a full-time student. If they are receiving public benefits, this is all of the public benefit stuff I just talked about. Having a medical condition that would require expensive treatment. If they're uninsured without a significant prospect of receiving private insurance or being able to pay for the care on their own, or if they've ever been determined to be a public charge in the past, that they applied before and were rejected on public charge grounds. But the heavily weighted positive factor is if they are over 250% of the federal poverty level, that's about $62,000 for a family of 4, that's heavily weighted in favor of entry. So again, if you're rich, come on in. You can get right past the invisible wall if you're rich, but if you're here because you want to work and build a life here, but are not rich to start with, then this will likely screen you out. It's important to remember that the statutory factors can't be changed by the regulation. They still have to consider these. The regulation, though, gives flesh to a lot of the things they're supposed to consider. So in the statute, if they're supposed to consider financial resources, this draws the line at 250% of the federal poverty level. If you make above that, then you're almost certain to be admitted. But negative factors can be outweighed by positive factors. And remember, some people are exempt from this. So one big question here is, given that we have under the 1996 welfare reform law, the PROARA, that created a 5-year bar for immigrants who are in the country before they can receive any federally funded public benefits. I think most people are familiar with the 5-year bar if you work on enrollment. So if most people, even once they become legal permanent residents, are still barred from public benefits, who is this really going to affect? Now, of course, the wealth factors, all of the age, the disability, ability to afford health insurance, those affect anyone seeking this status. But the public benefits part specifically is a relatively narrow category in here. And this is still, I'm not an immigration lawyer, and I don't know all of the possible categories, but here are some of the people who it might affect. One of the big ones are people who had legal permanent resident status and then left the country for more than 6 months, because those people have to seek readmission. They have to go through everything again. So someone who did receive received benefits as a legal permanent resident, left the country for 6 months, and is trying to be readmitted, that's a large group of people who will be considered here. There are some categories of permanent residents who lose status and then have to readjust later on. Some parolees who are qualified aliens. And then there are lots of people whose status, they seek to change their status through a family relationship instead of a pathway through where there would be an exemption from public charge. And those people would also be a large group of people who are accepted, because people can choose which route they're trying to establish their legal permanent residency on. And if it's through family relationship, then it's possible that it could affect them. And this would also apply to people who are granted a withholding of removal who choose a family-based pathway. But the bigger problem, this is a big problem, but is the climate of fear this creates. It's a complicated rule, and there's a lot of reporting now that immigrants are withdrawing their children from Head Start. They're not participating in WIC. There's been a real decline already in those numbers just based on the leaked drafts earlier this year. And that's one of the reasons why I wanted to be kind of very clear about who this affects. Legal permanent residents, there is nothing for them to worry about based on this rule, unless they're trying to get other family members admitted to the country. But I think it's that is the bigger worry right now for me, are the people who are entitled to benefits and who this rule would not apply to, who are withdrawing their children from benefits, withdrawing themselves from benefits that they're entitled to, simply based on fear. And there could be an even bigger reason for that fear, which is there is an indication that there is parallel rulemaking going on by the Department of Justice that could lead to considerations of public charge in deportation proceedings as well. Now, I don't want to be alarmist about this, but because that's all we know right now, is that there is rulemaking going on by the DOJ that could include public charge. We haven't seen even a leaked draft of those rules, so stay tuned for that, and definitely don't ring the alarm bell about this until we know what's in it, because we don't want to increase the fear in the community. But do stay tuned for what the DOJ is going to do with this. Okay, so what's the timing on this? Right now, this is a draft proposed rule. So this is the notice that is posted for public inspection, but it's not yet been published in the Federal Register. That we expect to happen any time now. We don't know what day, but that should be very soon. At that point, there's a 60-day comment period, and we are working, TJC and TIRC, the Tennessee Immigrant and Refugee Rights Coalition, are working on preparing some draft comments, and we hope either that your organization or individually will submit comments. We will have draft comments that you can just cut and paste. So we'll have resources available if you want to do this, but don't really know how to go about it. After that 60 days, the agency, DHS, will have to read and respond to the comments. They will have to publicly, in the final rule, they will note many people objected to this or something like that. So they do have to consider these comments, and it's really important to build a good administrative record if this rule is ever going to be challenged in court. And then after the agency has considered the comments, then they can publish the final rule. Okay, strategies to respond to this. First of all, again, the biggest worry right now are eligible people who are withdrawing from benefits or failing to apply for benefits because they're scared. So educating immigrant families so that we can fight off this chilling effect, make sure people know when they're subject to the rule. It's really important to say, if you've got a green card, you don't need to worry about public charge for yourself. Though family members, it may affect family members who are not legal permanent residents. And it's also important to know that it is only the applicant themselves who are considered for public charge. It's not their children, it's not other family members, it's not their sponsor. So if someone has a citizen child who's on Medicaid or Cover Kids, none of that is going to affect the individual's ability to adjust their status or enter the country. Talk to policymakers and urge them to oppose these changes. Again, this is a radical reshaping of U.S. immigration policy, bypassing Congress, and simply this is the Trump administration building their own invisible wall to keep out all but the richest immigrants. Then again, public comments are essential. We need a good administrative record on this, and I will at the end tell you how you can, or actually we'll send an email out after this to everybody who attended with how to sign up on a listserv that when we have draft comments or other information about developments, that we will get that information out to you. And then importantly, gather stories that document the harm to individuals and families and see if they're willing to share those publicly. It's really important that we know, that the public knows how this affects people, particularly people who are not enrolling in benefits, even though the rule would not affect them. We want those. We also want stories of people who would be affected by the rule. So if you want to know more about this or any other things we do, you can email Thomas, and I expect there will be some questions. So I will open it up now to questions. Okay, first question is it clear that a non-U.S. born child who arrives and does not yet have a green card can receive the discount for ACA enrollment? Right now, again, I don't immediately know the answer to this, but it's important to remember right now this doesn't apply to anyone. It's not until the final rule is in place, and then it'll be months after that before they are able to do the look back and see. In the email that Thomas will send out this afternoon, I will try to have an accurate answer to this. I don't want to answer off the cuff and misinform you. I think I know the answer, but let me do some research, and I will get back to you by email after the call. Other questions? There is something on your dashboard that okay, another question. To clarify, this does not affect people who are living in the country and in the process of applying for asylum. That's correct. Applicants for asylum are exempt. Basically, the people excluded from this are those humanitarian categories: the refugees, asylees, victims of human trafficking, certain child immigrants. So asylees or people seeking asylum are not going to be affected by this. It's not going to affect their ability to become asylees, at which point they would be totally exempt. So the asylees and refugees do not need to worry about this. Other questions you can ask on the dashboard? Oh, here they come. So often people get a work authorization card, a red card. These would be affected. Yes, those are people who would be affected. The big group of people who are considered non-immigrants, that are people who are not coming for permanent residence but on a work or a student visa, those are people who this would be affected. Someone is working with the Egyptian immigrant population, and they consistently ask whether the public charge will affect them when they apply for citizenship. Again, this does not affect applications for citizenship. This is only for people who are not legal permanent residents already and are seeking legal permanent residency status or are seeking to be admitted to the country. So if there are legal permanent residents applying for citizenship, it does not affect them. I got another one on the marketplace, the subsidies in the marketplace. As I mentioned, I will try to clarify that in a follow-up email to everyone. I just want to make sure that I've got that exactly right. Any other questions? Okay, well, thank you everybody for joining me. Wrapped up pretty quickly, but this is a complicated subject with lots of developing news. And we will, when the email comes after this, it will tell you how to sign up for the listserv so we can keep you updated on any changes to this. And you can always contact me directly, ccoleman@tnjustice.org, or Thomas if you want a broader training, and his email and number are on the screen. So thanks, everybody, and feel free to email me other questions, and I can try to put some in if I can find the answers between now and when the email goes out, I'll do that. So thanks, everybody.